Well, hello everybody. Welcome. I am showing 2 o'clock straight up. I have like 3 clocks here, 4 clocks, and they all tell a different time. So anyway, Stephanie, thank you. You're early today. Good to see you, Jessica. Thanks for being here, and everybody else as well. Here they all come. All right. So anyway, thank you all for being here today. We're gonna have some fun. I mean, somebody said to me once, you can take a dry topic like a statutory versus a contractual disclosure and make it actually interesting. And so hopefully I'll be able to do that for you today. And I know we've got a couple of transaction coordinators on the call today, which is kind of, I'm honored to know because gosh knows you're the front of the line, as we say, when it comes to the real estate transaction. So let's go ahead. Let's cover a couple things. I'm hoping I'll get input from you during the course of our conversation today. So and tell me what you're seeing out there. It's kind of important to me that I know what those things are. So anyway, we are at the Greater San Diego Association of Realtors, and my name is Kevin Burke. There is my telephone number. Listen, call me anytime. I am happy to help in any way that I can. And so somebody asked me a broker asked me last night. He said, every time I get off the phone with you, I feel like I've been in therapy. And so I thought, wow, what a nice thing to say. But he says, you're calm. You've always got the answers. You tell me if you don't, which is rare. But anyway, call me. I'd like to talk with you because it's kind of fun for me. So anyway, I do. Not necessarily every time somebody calls me, it's a problem. Sometimes it's an interesting situation. So please feel free. So there's my telephone number. There's my email address. Sometimes email is easier. But I do want to speak with you, and I always say speak with you, not speak to you. So thank you for being here today. So I do have some credentials that make me qualified to speak about the subject matter. I have a broker's license on both coasts. I am well in excess of 40 years in the real estate industry and just keeps on going. I don't know if I'm going to hit 100 years in real estate, but I'll sure try. I do teach continuing education. Down that goes. Continuing education for attorneys. So we're in the middle of a class right now, in fact. I was thinking on my way to the forum here that I'm just gonna start kicking these things up to the DRE for approval because I teach a lot of these classes, and you might as well get credit for them other than just the knowledge. But of course, if we do DRE credit, then you're gonna have to pay for it. So because it's expensive. But anyway, for now, this is just for your information. So let's see, legal aspects, real estate. On the right-hand side, risk management. I will be adding to that title as we get closer to the beginning of January. I will be adding that I will be the chair of legal affairs for the California Association of Realtors. So somebody thinks I know what I'm doing, and so I'm kind of honored to be there. But that's the way that it is. Okay. So anyway, so happy to help you in any way that I can. We're going to be talking about stuff today, clearly that's going to appear to be legal. And I want it on the record that I am not a practicing attorney. I have no interest. They work harder than we do. We make more money than they do. And people think that they're 9 to 5 Monday through Friday. I don't know an attorney that turns the clock off at 5 o'clock. A lot of the attorneys that I get their cell phone numbers. They want me to get a hold of them. I'm talking to them on Saturday morning, things like that. So it's a lot of work. I just knew that I was, when I got my law degree, I was in the middle of my 40 years. And I just knew I just enjoyed this so much that, and I hope you do too. I hope you're enjoying it. So trial work, yeah, I do a lot of it. Limited to testifying as an expert witness. Again, it's court certified expert witness. Standard of care for real estate licensees, agents' duties of inspection and disclosure, and market conditions in San Diego County. Holly's not with us yet. She keeps me on track as far as making sure that I'm on the right slide. Now that I've changed I have two computers. I need a third computer, but two computers, and I have to go that way to look to see if I've got it on the right slide. So anyway, conversation today not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Remember, they're a broker for a reason. They've put their neck out there to make sure that everybody's okay, and they're held held to a higher standard. So, you need to definitely be consulting with your broker. One of the things, I had a call last night from one of Linda's agents, and it was an hour-long phone call. Something really bad happened at a showing, and so we had a long conversation about how that was handled, and it was handled well. And so you definitely need to be talking to your broker about those things. Okay, so our talk today is intended to be interactive. Please, especially if you're a transaction coordinator, I want to hear from you. Ask questions, offer input, utilize the Q&A button. And I do look forward to hearing from you. So again, thank you for being here. So this morning we did the TDS, the SPQ, the SPQA, and the AVID. And I just think and of course that it's not July the 11th, but I think that we did knock that one out of the park. And again, not July 11th, we're on August the 24th or something. Disclosures, statutory versus contractual. And then of course, Thursday, which will be the 26th, Master My Farm. Boy, did I miss that up, right? And then in the afternoon, we'll be doing how to create the winning listing presentation. One of my best presentations, I think. I do like doing that. I'm tailoring that to go to teach on both coasts now because I'm clearly doing the education process. I'm a D4 certified instructor, which is the equivalent of a DRE instructor in the state of Virginia. So I always believed in buying property and getting my broker's license where I had family. That way, when I traveled, I could get tax benefits from it. So I always tell my family, "You're just a tax benefit to me." So anyway, it's not true, but it's fun. So anyway, thank you for joining us for our discussion of disclosures, statutory or contractual. And we're going to move along at a pretty good clip today. I have a lot to show you and a lot to talk to you about. So today's conversation is going to be to focus on disclosures in the residential real estate sales transaction. So I do commercial as well, and I do trial work on commercial transactions. And I can tell you that it is a whole different ball game than it is in the residential field. In residential, we're subject to California Civil Code 1102. Which is intended to protect the innocent buyer and seller who I think some of us know are not so innocent, but in the residential 1 to 4, which means single family home, duplex, triplex, fourplex, and those are considered by the legislative body to be the innocent buyer and seller. Once we get into 5s and graders, now we're going to get into UCC, which is otherwise known as Uniform Commercial Code, which is nationwide kind of stuff. And really there, it's just y'all be careful, that kind of thing. And everybody's got lawyers and everybody uses the lawyers. And so I just did a commercial transaction up in Solomar. And again, I do commercials, so I wasn't surprised. There was almost like no disclosures at all. But I was asking the broker, one of Linda's brokers, about, the property had some water on the floor, and I asked the broker because I hadn't been to the property, and I said, is it like glowing? Is it iridescent? Is it multiple colors? And so that's usually a signal that you might have some hazardous waste or something along that line. So just a very different world. So anyway, today's residential. We're going to distinguish between the disclosures required of the seller, but also the real estate agent. What does the real estate agent have to do? And so again, statutory versus contractual. So statutory, why are they required? In California, there is no caveat emptor. Okay, that went away with the Easton case, and the Easton case was a transaction that occurred back in 1976, and the appellate decision occurred in 84, and it has changed the landscape of how we do real estate. So there is no buyer beware in California. And instead, it's caveat vendor, which is let the seller beware. So East and West Coast have different approaches to the issue. California, you got to disclose everything, all right? And so if you're doing transactional work for people, that those disclosures are tantamount. They are the most important thing that we are doing in the real estate transaction. I mean, we're putting together, an agreement between buyer and seller, but at the same time, if you don't do the disclosures right in California, you're going to have a problem, okay? So in Virginia, it's just best not to say anything. Completely the opposite. I did a transaction with an agent. So we were the seller's agent in in Carlsbad, and the buyer's agent had just moved to San Diego County from Virginia, where again, completely opposite disclosure issues. They were shocked at all the disclosures that were required in California. It was their first transaction, and so and it went really well for them. But they were just amazed at the differences between the two states. I think they're two different countries, but that's just my personal perspective. So why are they required? So the seller, again, to assure that those with the most knowledge of the property share that information with the buyer. The standard of care for the seller is that they knew or should have known. So think about that. And that, by the way, that standard is not quite as heavy on the real estate agent, but if the real estate brokerage has handled that property in the past, probably best to provide those disclosures from that previous transaction. Okay, again, check with your broker. I did have a broker call me last night. She says, I sold them the property about 6 months ago. Do I need to be giving them now we're putting it on the market for sale. So I don't know, might be a flip, right? Do I need to be giving the disclosures from that transaction to the buyer that comes to us with the offer? And my counsel, of course, was I would. Right. In the immortal words of Pete Selecki, they can't sue you for what you tell them. And Pete was our attorney with the Rock people, and he was our attorney also with SDAR. I'm assuming he's still the attorney. I don't have as much interaction with him now that I'm no longer president. But again, knew or should have known. And so again, when my flipper goes to sell, they're going to be held to the standard of all the disclosures that they got when they purchased the property, plus any repairs that they might have done, anything like that. So we need to be diligent about that when we're doing our receipt for reports and things like that. Okay, so the agent, to assure that the real estate professional does their due diligence in the real estate transaction. And so I know some of this is similar to what we talked about on Tuesday, but I assure you we're going to go in a completely different direction. We're going to talk about the notice of default purchase agreement and Civil Code 1695 and some things like that. And so the real estate licensee has an obligation to provide those forms necessary for their client to complete their transaction, client being someone they have a written agreement with, all right? By virtue of their license, the real estate licensee is authorized to explain the standard forms. Again, why do we have standard forms? We have standard forms because if we relied on ourselves as real estate agents, we'd have 12 million different variations of a theme, of disclosures, of contract types, of things like that. And so, back in, I should have brought up the one page, I have the one page purchase agreement that I used when I first got into real estate in California. Our contract was one page. It is 16 pages, and there's a reason for that. And the reason is because, we would keep writing things on our own, filling in the blank. I mean, big, extensive blanks. And to a point where the California Association of Realtors stepped in and said, hey, you know what? Y'all are saying this stuff. Let's make it legalese kind of thing. And then our contracts just grew and grew and grew. They went from a 1 page to a 2 to a 4 to an 8. And then everybody thought, oh, we're going to go back to the 6, right? No. We went from 8 to 10, and then we just kind of stuck on 10 for a long period of time, and we were decreasing font sizes and changing spacing in between paragraphs, everything we could do to keep it at 10. And finally, we just said, we just got to bust out of this. So we went to a 16-page contract, and it's not the end of it. We're going to keep going, but you have the power as a licensee to explain the standard form. And again, the standard form is that form that is commonly used in the business. And you can count on the fact that the CAR library, the zip forms library, are the standard forms. Okay. Any questions on any of that so far? So how about the agent? Again, how about the agent? A reasonably competent and diligent visual inspection. Visual inspection, okay, again, and to disclose to a prospective purchaser any facts that affect the value or desirability of the property. And so that comes right out of the Easton case. And the Easton case was famous, that such an investigation would reveal. And gosh knows, there we go, Easton versus Strasburger. So the precursor to California Civil Code 2079. 2079 is our obligation to disclose to the client what we saw or what we should have been aware of. And so I'm not going to go deep into it. We don't have time, but I do have the annotated version here, which of course there it is. A simple case: the seller sold a property through their real estate agent. The buyer, Easton, purchased the property. I'm just going to give you the Cliff Note version here really quick. The buyer did purchase the property. At the time, the standard for the seller was, I don't have to do anything. I don't have to tell you anything. And sure enough, there were some slippery slopes, as we call it. They're going to say massive earth movements. And this is in the language. This is from the case. So this is the language that the judges wrote when they did their opinion. So the earth movement destroyed a portion of the property. It was a significant thing. And at one point, after Easton purchased the home, the property was valued at roughly $20,000 from the 170 that they paid for it, and it looked like there was going to be repairs that were going to be required up to essentially $213,000. So unfortunately, the seller did not tell the buyer, but they also did not tell the agent. But the court came back and said that the agent should have had a pretty good idea that something was wrong with the property, right? Because what? There were red flags. And that indicated to them that there were some soil stability issues. There was some netting around the property, kind of holding the property down. There had been, again, some significant failures, sinkholes, things like that. But in addition to that, the agents who should have realized that the floors weren't level, right? You ever walked around? I mean, I remember being in a house in Oceanfront in Del Mar where it's very clear that this is not a level, a floor. The second floor was clearly not level. I don't need to have a manometer reading done to know that maybe I should be telling the buyer, you really need to have a soils expert look at this. You really need to have and again, are we going to require the agent to do the soils investigation? No, but we really need to be clear to the buyer that they should be doing that. So Strasburgers didn't tell the agents anything about the slides or the corrective action that they had taken, and so the buyer bought the property without being aware of any of that. All right, so negligence is what we're talking about, and in this case, the seller, of course, was intentionally misrepresenting the property. And fraudulent concealments, perhaps, as well, even though they backed away from those claims. But the real estate agents had been also named as being negligent. They should have known better, and they should have said something about it. So that's the Easton case. So again, we started off with no obligation to tell anybody anything, and then all of a sudden we're in it as far as we have an obligation to do a reasonably competent, diligent. I'm going to take you to that part, and then we'll get out of the Easton case because, again, I don't want to spend too much time on it. But I've annotated this for you. So here it is. Now, folks, you're doing real estate transactions. Have you seen this before? Okay, so the affirmative duty to conduct a reasonably competent and diligent inspection of the residential property listed for sale and to disclose to prospective purchasers all facts materially affecting the value or desirability of the property that such an investigation would reveal. I mean, there it is. This is where you see this in your TDS on page 3. You see this on your Avid on page 3. You see it on page 1 of the Avid. You see it in almost everything that we do. And again, so that's our Easton case. Easton was an amazing case. I mean, I've probably read it so many times that I can tell you that I almost have it memorized. But by the way, that reasonably competent, diligent visual inspection of the property, visual wasn't in the original case, but it became part of the standard. And the reason is because the agent has an obligation to inspect the property. The buyer has an obligation to investigate the property. Two very different standards. The agent is not held to the standard that the buyer is held to. And frankly, the agent maybe oversteps their authority. They're picking locks to get into rooms. They're lifting boxes. I remember that we did a real estate transaction in Del Mar where the house was on the side of a hill. So there's 5 floors, all of them pancaked against the side of the hill. And down in the very bottom floor, every floor had a room, right? And we get down to the bottom floor, and our agents noticed that there was that smell about the property, an odor about the property, but it was up to the ceiling in boxes. And so, did the agent have an obligation to move any of the boxes? And the answer is no. You don't need to go to heroic efforts. You just need to be, I always say, even though it says a visual, I always say you need to be in there with your five senses. You really need to be doing your inspection with the five senses. And so the agents in this case, had noticed that there was a problem. There was a smell, there was an odor. They noted it in their inspection that there was an odor, but they couldn't get to the walls. And so, sure enough, seller moves out, buyer moves in, and oh my gosh, that floor where that room was, the walls were covered in black stains, shall we call them. Come to find out later on, it's stachybotrys, which is toxic mold, right? But did the agents have any idea? No. They just smelled something that was really out of the ordinary, and they noted it in their report. But again, they did not move anything. No obligation to move anything. I remember that the buyer, of course, litigated against the seller, and the attorney called me on the phone and had a couple of questions. And I love talking to lawyers. I don't know what it is. It's so much fun for me. And so then I get the lawyer. I'm talking to the lawyer and all that kind of stuff. They decided early in the case that they didn't need me. And again, remember, we're the broker. And so the buyer's broker. And so they said, we don't need you. We got this. And yeah, I think you do. So needless to say, it comes out, never did go to trial. I mean, in deposition, it comes out that the seller actually had received a check from their insurance company to repair the damage. There had been multiple attempts to repair the damage to the property, and they just didn't bother to disclose it, and their agent didn't tell them about their obligation to disclose it. So, so spin this around. We look at Civil Code 2079, which is the rule that you and I are subject to, and the Civil Code is really clear. Easton's, I think, a great case. I think it really did change the benchmark, and I think that and it changed the way that we do business. A real estate licensee has a duty to disclose to a buyer material defects known to the broker, but unknown to and unobservable by the buyer. And again, this is out of the Easton case, so this has changed a little bit since that time. So to the buyer, material defects. Now, you're not qualified to determine what is material and what's not material, okay? So I would say, pretty much any defect, you might want to bring that up, but is it material to that buyer? Is that buyer going to have a problem with something? It's like the old story of, the buyer wants to get out of the real estate transaction because the lights in the kitchen don't work, right? Okay, all right. If it's an electrical problem, then that might be considered a material defect. But if it's just light bulbs that aren't working, that's probably not going to fly, right? And again, when we've got the guy or the gal in the robe making the decision for us as to whether or not it was material, it's very expensive to get there. The Easton case, it was, they had the case at the local court, the Superior Court, and the plaintiff was successful. The real estate brokerage appealed to the California appellate. And by the way, you've got millions of dollars in legal fees at the local level, and then you get up into the appellates, and it's just really amazing the amount of money. And that case was denied by the Supremes, as I call them, the Supremes, right? The Supreme Court in California. They said, no, we're not going to hear it. The case was, it's going to stand on its merit at the lower court. So they denied hearing the case. So material defect is going to be, something that causes a lot of settlement. Okay, no pun intended. So again, unknown to and unobservable by the buyer. Now, see, I take umbrage with that because in the Easton case, the buyer saw the cracks in the pool. They saw the netting holding the property up. They were aware of the fact that the floors were uneven. So I don't know, but I think we have a principle of law called bootstrapping, which means they had the result they wanted to get to, so they got to that result. But then they made the dicta, which is something we follow today. Okay, if a broker fails to disclose known material facts, he or she is liable for fraudulent concealment, right? Fraud, very bad word. Okay, fraud, big word, big four-letter word, right? Or for negligent misrepresentation, which is what happened in the Easton case, right? They knew better. They should, even though the seller did not tell them about the work, about the problem or the work that they had done, they were still very much aware that there had been a problem. Okay, all right. So then we get into the Field case, which is imposes a greater fiduciary duty on the selling agent. That's the buyer's agent. Let's just take a look at Field field real quick. Again, I don't want to spend a lot of time on the court cases, but because we have a lot to talk about. But here's field. Century 21 Cloud and Furness, good real estate company. This one just was a transaction did not go well. Okay, so essentially, it was really not a case against the real estate agent company. It was really a statute of limitations case. And so 2079, which came out of the Easton case, all right, and they're going to quote Easton in this case, but 2079 says that this is our obligation, our duty of what to do. By the way, I say duty, but I'm not allowed to say that in court. That's the judge's decision. So again, if you're in court on that issue, we had the Hariki case, which came down a couple of years ago now. I had a case that went to judgment the same day as Hariki came down. And by the way, the Hariki case is an appellate level. I'm at the Superior Court level, and we came to the same decision in our case that Hariki came down to. But again, the field case is a statute of limitations case. And so, but here we go. We're going to quote Easton. We're going to, reasonable visual inspection of the marketed property, et cetera, et cetera. So in the field case, just to give you an idea, it was a rural residence at the time. It's completely surrounded by property now, but the real estate agent indicated that the property, that the boundaries of the property were other than they actually were, as well as the fact that the Otay Water District had the ability to dump a water tank up on a hill, and you've probably all driven by it and seen it, but that they could dump the tank. They had an easement against the property that the fields were buying, an easement against the property that said, when we dump that water tank, it's going to flood your property. And oh, by the way, also your residence. And so, unfortunately for the buyer, they did not get the preliminary title report until after close of escrow. So you can only imagine that they get the prelim, they open the prelim up, and they go, "Oh my gosh, we had no idea." And again, the real estate agent had said that the property was larger than it really was, that the easement against the property from Otay Water District was smaller than it really was, and so again, but there was never an opportunity to explain it. This is why I tell you, watch my video, how to read a preliminary title report, right? Because it's really, really important. Here we go. Easement was more extensive, substantially more intrusive, covered more area, and including some area occupied by the residents. This is just bad news. Unfortunately, the agent was aware that the easement existed, but never verified the extent of it. So again, making representations that were unfortunately later on turned out to be wrong. So that's my difference between intentional misrepresentation and negligent misrepresentation. Intentional is she intended to deceive them when she knew otherwise, but in fact, she didn't know otherwise, and she never looked it up. She never did any research on it. She never told them to do it. And so at the end of the day, they took her word for it. And even the court said, we're not going to require them to investigate the property on that realm when the agent represents the fact that this was, here's the, do not inspect the prelim, but we're not going to make them investigate further when the agent was so adamant about the fact that this was no big deal. Okay, so anyway, that's the field case, and that came right out of our backyard here, Otay Water District. And again, when I pull this up, and I'll send all this to you if you want copies of this. So the appellate decision was in 1998, which again, the case itself started in excuse me, 1992, if I remember correctly, but bad news. And so, but again, good real estate company, but this part here, listen, folks, important, prelim, you need to be going over that. For those of you that are doing transactional work, I would have the buyer initial page 1 of the preliminary title report, just so you can prove. And I understand escrow got copies of stuff, but remember, if there's a lawsuit on anything, remember that escrow is going to lock up and say, you're on your own. We'll defend ourselves with what we've got. You need to defend yourself with what you've got. So get copies. Get all that stuff taken care of by the buyer at the time that you put. Hi, Holly. At the time you put the transaction together. Okay. All right. Everybody good with that? So that's again the field case, and I've done this presentation for roughly 4 times this week, and each time we grab the case from a different angle. So again, field greater fiduciary duty on the selling, the buyer's agent. And so standard of care, let's talk about that. A real estate licensee must use the degree of care that a reasonably prudent real estate licensee would exercise, and is measured by the degree of knowledge through education, experience, and examination required to obtain a real estate license. So again, remember, and this, I always enjoy this, the real estate agent calling me on the phone, asking me legal questions. I go, I don't know what to tell you. My standard is your standard, and that is stay in your lane. You are going to be held accountable for the education, based on the education that you had to get your real estate license. So when you start opining about other things, you're creating problems for yourself. Like my case with the Harbor property, where the buyer's agent was with the buyer, on the boat slip, and he had sold other properties before on the harbor, and the buyer, was low tide. The buyer says to him, how does the stem wall look to you? And the agent, of course, who thought they knew what a stem wall was, said, it looks fine to me. Millions of dollars later, I made a lot of money on that one, right? Because the agent, you never should have said, because your job, you're not a contractor, and you certainly are not an expert in boat. And I met enough experts in that case to know that don't ever, and it wasn't even the stem wall. What he saw wasn't even the stem wall. And he said, the stem wall looks fine to me. And we're off to the races. And of course, everybody knew the buyer was an attorney. And so the next thing you know, they just felt like they overpaid for the property. And so let the games begin. Okay. So, I feel like my job is to keep us out of that, that place. So stay within your lane. This quote, by the way, came from a gentleman I really had a tremendous amount of respect for, Wayne Bell, who was the commissioner before Macaulay. Macaulay's a great commissioner. I like him. I've liked most all of the commissioners. But Wayne Bell was an attorney. He was the head of enforcement for 20 years. And then he became the commissioner, and he was the commissioner for a long period of time. And then he was replaced because of politics and stuff like that, which I know we can all relate to that, right? But anyway, super guy. He's doing well today. We have conversed in the past, and so I just like him. So anyway, great quote. So that should relieve you, right? Of oh my gosh, am I going to be held to this standard? I'm telling you that this is not as big a deal as you think, but this is a big deal that we need to make these disclosures. Okay, so some even have the potential of costing you your license. What's the difference? Statutory disclosures, just really quick, I want to go through this. So they contain rescission rights. That means put the parties back in the position that they were in prior to the contract. So imagine for a second that you put a transaction together, and you're 2 weeks later, the seller's agent provides you with the TDS, the NHD, and all those things. Guess what? The buyer might have the ability, based on rescission rights, to exit the contract, which means you're probably going to be given back the deposit, or they're going to try to renegotiate the deal. And you, as a seller's agent, are going to have to try to make excuses to the seller about how come they got away with that. Well, it's because you didn't give them the disclosures. So I truly believe that you should have the seller complete all of the disclosures at the time of the listing, and then provide those to the buyer at the time of the contract. When you do that, they don't get their rescission rights. Okay, so first form I want to talk about is my agency disclosure form, and that's going to be CAR form AD, and that's going to be Civil Code 2079.13. So I'm just going to pull it up really fast. We're not going to spend a lot of time on the individual forms, especially because they're going to be starting to turn me off here in a second. So I'm in my templates. Let me go back to my list. So here's my templates. So I have templates for everything. Right? Okay. Why? Because my business is a rote business. And again, if you're doing transactional work, then you know what I'm talking about. We do a lot of times do the same things again and again. So I have a seller listing template, a buyer offer template, a property management template, a lease template. I have templates for everything. Okay. So today, we're going to go into my template that I created for this class, which is my disclosures, statutory or contractual. Okay, and so as you can see from the template, I've got the purchase agreement in here because I want to be able to reference it. But my two characters over here on the left-hand side are going to be my statutory disclosures, and then we got the NHD included in here, and then we also have contractual disclosures. So let's go ahead. I'm going to click on, and I have all the sales disclosure charts. All right, so yes, you can see those. Let me pull those up for you just really fast. So get rid of field. So here's my sales disclosure chart. Make sure you're using the current version. All right. So this is the one from January of 2023. Again, revised. And again, as I said earlier, I'll send all this to you. But if you're wondering what the disclosures are, and I dissected this entire thing. Okay. So why? Because it's important. So like, for example, title insurance. There's no law in California that requires title insurance. A lot of people think there is, but there isn't. But who requires it? Well, the lender requires it if there's a lender, right? And so why? Because it just, the courts have said it makes good sense, it's readily available, it's fairly inexpensive, it's good business. And so, but I've had situations where, buyers paying cash and the real estate agent said, you don't need title insurance, don't worry about it. The lender requires it. So you knew just maybe a little bit too much. And then your buyer ended up buying the property without title insurance. So again, and it's Civil Code 1057.6. So anyway, and this talks about the when and stuff like that. And so my issue with the form is that the headings don't follow, but agency disclosure, it's just in everything. It used to be only in residential 1 to 4, but then we came back and we said, we think it should be in commercial and vacant land and in personal property, mobile homes. And so that became, here it is over here, my Civil Code 2079, et sequitur just means and following. And so we're going to talk about these things today. So I'm not going to spend too much time on this. Here's an additional disclosure. This is going to be, where is it down here? Whoops, where'd it go? Okay, there it is. And we'll make it get a little bit bigger. So my statutorily or contractually required disclosures. Again, my hat is off to the California Association of Realtors. They create such great stuff. But once they create it, they go, got that one done, and then they move on to something else. Well, they forget to tell us that what they've done. And so they got some great stuff in here. Look, you have clickable links, TDS and the SPQ, your Avid, all of this stuff. I have burned through all of these. I've gone through all of them. Buyer's inspection advisory, no longer called the buyer's inspection advisory. So there's a little typo there. It's the buyer's investigation advisory, right? Because why? Because the buyer, we got smart. Fortunately, it had an I in it, so we were able to get away with it. But that's the name of the form today, is the buyer's investigation advisory. So anyway, lots of really good stuff in there. I wanted to make that available to you so you could see it. Let's go back to my forms here really quick. Actually, whoops, let me go back to my my PowerPoint, right? So agency disclosure. So let's talk about my agency disclosure. So I'm going to pull that up. Again, we're not going to spend the day on it, but we are going to spend some time on it. Statutory disclosure. It's very much a statutory disclosure. Okay, so let's pull up my agency disclosure. I'm going to go full screen on you. And again, I have just the form here today. And again, please slow me down. And if you have questions about any of this, because I frequently see this one done incorrectly. So again, we changed the language in the law where it used to say the listing agent and the selling agent. It was confusing to us. The Department of Real Estate knew it was confusing to us. So it was on the state exam. I mean, I used to teach the state exam. There were all kinds of parts to it that were, we're just going to talk about, here's the language you think so we changed it. We changed it to go to plain English. We wanted it to be in plain English, right? So we did. We changed the stat. And this was in October of 18. Then we changed it again when we got to the new RPA, which occurred in 12 of 21. We did a new RPA, and so we changed it again. And again, we've attached it there. Here's your fiduciary duties, which I have problems with that because essentially they're using it to define itself. But if you really want to understand the Civil Code 2079, you go to page 2. Because here it is. This is the part in the old days, the statute was always 2 pages. And in the old days, we would throw away page 2 because there wasn't anything to sign on it. In fact, we didn't even have initial places on it. So, we used to throw it away. And it's like, oh, no. Well, I didn't throw it away, right? Okay. But, people were throwing it away because they didn't understand what the point was. Well, it's because we want to make sure that the buyer has an opportunity to read the Civil Code, okay? And so this is essentially straight out of the legislation, Civil Code. Again, here it is, 2079.13. And all we did was put the CAR our logo on it up here in the left-hand corner. And then, of course, we've got our logo over here in the right-hand corner. And by the way, that's not inexpensive. It's like, I don't know, $100 or something that you can go, and CAR will put your logo up here. And whether it's your team logo, check with your broker, make sure that's okay. But again, I have a company right now that I'm counseling that has they're going to put their logo up on the right-hand corner, and they're going to have the broker version, and their agents are all going to use the broker version of Zip Forms. So this is the agency disclosure. I could spend an hour and a half. In fact, I was asked by an attorney to do a class on agency for the association, and so I'm trying to think of how I could do that in an hour. It's a very complicated subject, but I assure you, I do trial work on this, and so it can get really ugly. So I wanted to point that out to you. Let's go. I want to go from there because we're going to hopefully not run out of time. But that's Civil Code again, 2079. The first form your client should ever sign. Again, check with your broker. Your broker could have a different policy, but in Linda's brokerage, the very first form your client ever signs is going to be the agency disclosure. Wayne Bell, the commissioner, said to me in a meeting, he said, we think you should be providing it to the person that walks into your open house. You should have the disclosure done at that point. In Virginia, the law says before you have a substantive conversation. And so when you have a substantive conversation about a particular property, then you're required by law to get this, and by the way, the buyer representation agreement signed. That's coming to a theater near you, folks, because, listen, on the NAR level, I was in a meeting a week or two ago, and we did everything we could to keep it from becoming legislation in California when we released the new BRBC. But my hat is off to that task force. Kathy Merringer, the broker for Compass, there were some big brokers in that meeting, and I personally think it should be legislatively required. But it's coming. They said, and rightfully so, it just wasn't time. It's going to happen. So if you're not really comfortable with the buyer representation agreement, I'm giving you a heads up. Get comfortable with it. In other states, it's required by statute. Virginia, for example, July 1 of last year, they made it a law. You have to have one with the buyer. Otherwise, you're misrepresenting the buyer. So be aware of that. Agency disclosure, critically important. First form you ever have your client sign, and give them a copy right away. Okay, so the law says, the law used to say you have to give them a copy of that, when they sign it, but the law changed and said now it says that you just have to give them a copy within 24 hours. Okay, so that's a DRE regulation. I really shouldn't call it a law. It's not a law, it's a regulation, although it actually might be a law as well. So be aware of that. All right. Form AC, this is when we mess up the agency disclosure. So page 2 of the RPA, let's take a look at my page 2 of the RPA again. Oops, I went to the wrong place. Hang on a second, don't go anywhere. The RPA, this is fascinating stuff for me. So I'm going to go to my back to my RPA here, and I'm going to go, let's see, we'll talk about that in a minute. But I'm going to go to paragraph number 2. So let's go there. And so you all see right here. So paragraph number 2 is agency. Okay, so remember that agency disclosure we just talked about. The law says you must disclose agency prior to committing conduct that constitutes agency. I'm familiar, by the way, with a case where the Department of Real Estate took a $66,000 commission away from a brokerage, and this was 20 years ago when $66,000 was a lot of money, and they took the money away from the brokerage. The transaction coordinator discovered the day before closing that the parties had not received the agency disclosure, and so the Department of Real Estate said, yeah, you got it before you closed, but we really think that was way too late. That should have happened before they wrote the offer, before the contract came together. And so, listen, I don't want to be a test case, and I know you don't want to either, but I must give that agency disclosure. We've even attached it to your forms. You can't miss it, okay? So agency disclosure prior to committing conduct that constitutes agency, right? Because at that point, we know we're a single agent. We don't know if we're going to possibly become a dual agent, right? But the law says we must disclose the concept, and then we must later confirm. And that's what paragraph 2 does. In paragraph 2 of your purchase agreement, we confirm agency. And I remember the district manager for the Department of Real Estate coming into a meeting and saying, a meeting at the risk management in San Diego, and saying that, it used to be paragraph number 17. It was at the back of the contract. And so she said, we think you're doing it wrong. We think it needs to be up towards the front of the contract. Oh my. And next thing you know, it's paragraph number 2. Okay. So it's right up front. So again, this has to be completed properly. So again, for those of you doing transaction work, if it's not completed properly, then you need to have it have the AC6 form or the AC form completed. So again, our company's name is misspelled frequently. Our MLS truncates our name because it's so long, Burke Real Estate Consultants Inc. And so what they did is they took out all the spaces, so it's one great big long word. So when you do the MLS Connect, it shows up as seller's brokerage firm. It shows up, at truncated. Well, we feel that means that we need to fix that. I mean, somebody needed to go in and put the spaces in there, but most agents don't. But okay, so at that point, what we do is we have to go ahead and fix the agency confirmation. So we're going to go in and we're going to grab the AC form, which is the confirmation of real estate agency relationships form, and that's this form here. Okay, so be very attentive to this. If they don't have the DRE number correct, right? If they don't have the DRE number correct for the broker, and we see that today when we're doing that MLS Connect feature, so for example, back over to here, they don't have the seller's broker, or it'll have the MLS number, which is not the appropriate number. So the Department of Real Estate has said, we want the public to readily be able to find you. That's the point behind having the DRE numbers next to the broker's DRE number and the agent's DRE number. And actually we lobbied for that at the California Association of Realtors level. So, we want to make sure everybody knows that we are real estate professionals. So this needs to be done the right way. And again, if they've got the MLS number for the broker and not the broker's DRE number, then we need to correct that here. Okay. So again, for those of you doing transactional work, you might end up fixing things if it wasn't done properly. I've seen people write offers and get their own broker number wrong. So, so you need to be attentive to that. We look everybody up. We pull up their DRE. We pull up their broker's DRE. We print the DRE information on the individual. We print the DRE information on the broker, and we save that in our file here. Again, we've had people write offers under an expired license. And remember, if the broker's license is expired, then that means everybody under the broker's also expired. So, and we're just not going to be able to talk to you. I mean, it's like you don't have a license, right? Okay, so and there can be some exceptions to that, but anyway, so that's what this is all about. And so we fix it here, and then we have everybody sign it that says everybody's aware of the fact that we're going to confirm agency because the law requires us to do that. Is everybody good with that? Okay, really important. I wanted to show that to you really quick. Let's go back. So again, that's my AC. We call it the AC6 because it used to be on 6-inch paper kind of thing, and we just don't do that anymore. So it's only intended to fix a problem with page 2 of the RPA. Okay. Then we have our lead-based paint, and again, we're going to talk about a handful of forms here, but we have way too much to do to cover all of them. But lead-based paint, you're all very aware of the fact. CAR form LPD, it changed, right? It used to be the FLD, but now it's the LPD, and that's the federal lead-based paint disclosure form. The penalties for not doing this are up to $200,000 per offense. Listen, I know most of you are driving cars that cost $200,000, but if you don't have to give it to anybody, let's not do that. Okay, so my lead paint form is for use in properties that were built pre-1978. Let's pull that up here really quick. So pre-1978, notice that it's for sales and leases and rentals. I don't care what it is. If it was built prior to 1978, we must make the disclosure. Now, as I've said in other webinars, I went to the YouTube video and looked up, what happens to a child that's been chewing on these lead-based paint. It is truly, please don't go there. It is really heartbreaking, but it does permanent brain damage. It's sweet tasting. Kids don't know any better, and they're chewing on these things. We see more of it on the East Coast than we do on the West Coast. But this is a serious law regulation. It's really not a law; it's a regulation. It is an EPA regulation, so they can move around, and they've changed a couple things on it fairly recently. So you have the renovation rule that changed, and that says it's going to apply. If there are more than 6 square feet of lead-based paint in a room, right, and it's also or more than 20 square feet on the exterior. It has to be remediated by a professional company that follows the different things that they're supposed to follow. Okay, so my lead-based paint. By the way, I see this filled out incorrectly all the time. If so, paragraph number 1 says the seller has no knowledge of lead-based paint. So, other than the following, so if you leave it blank, it's incomplete. Does everybody understand what I'm saying? It's incomplete. So you don't want to leave it blank. So what you need to do is you put up here NA or nothing noted or stuff like that. Same thing with the second part. So it says, other than, and so we want to make sure that we have covered that. These forms are incomplete if not filled out. Okay, and then I get down to sales transactions. The buyer's got 10 days to do a lead assessment by law, okay, by regulation again. But whereas I'm going to have my U.S. code in here. Where did it go? Here we go. 42 U.S. code 4528D. So obligations under the U.S. code. Okay. So important issue. Let me pull back up my PowerPoint again. Significant event. Violators of the legislation may face civil and or criminal penalties. So imagine that you've been handling property management for a building that was built in 1976 and you've never done the lead-based paint. So, I'm familiar with cases where, it'll pretty much put you out of business. Okay, 64 units, yeah, times. Okay, so it'll put you out of business. So be really careful, be very well aware, get this done right. There could be treble damages, what we call, I should have changed that. Triple damages is what the public sees, but it's called treble, T-R-E-B-L-E, in a private lawsuit, subject to treble damages, which is 3 times the amount of the issue. So sellers must provide the home buyer a 10-day period to conduct a paint inspection or risk assessment for those paints. Parties may mutually agree, in this case at least, in writing only, to lengthen or shorten the time period for inspection. The buyer could waive it, okay? But this is one of those rare exceptions. I don't have any kids, I have dogs, whatever. But any property built prior to 78, people call me all the time. Well, we did a complete remodel in 2003. Well, I don't know what a complete remodel is. I mean, you tell me, what does that mean? Down to the foundation, down to the studs, what? I don't know. So I never say complete remodel in any of my marketing materials. Real estate transfer disclosure statement. We killed this morning. We really spent a lot of time on it. I love my TDS. It's a great form. Let's take a look at it up here really fast. This morning's presentation drilled into this, but we're not going to spend quite as much time on it now. But again, I've just never seen one filled out correctly. It just is new form as of 6/23 at 1:26 or 1:30 in the afternoon. We had revised this, legislatively revised it, and all of that revision is up here towards the top. Make sure that you put in the date. So this would be the date that the seller makes the disclosure. As of this date, this is the situation. Section 1, frequently, ignored. We changed the body of the document to include no substituted disclosures for this transfer. People ask me all the time, should I check that box? And I say, well, you would check. They want you to check. The legislative intent is that you check the box if the first 2 don't apply. Okay, so I have a really good Q&A from CAR on substituted disclosure disclosures. If you want copies of all that, send me an email. I'm happy to send it to you. But I think in most of the transactions you do, the seller's going to check that box. You'll notice you don't have the ability to fill it out. If you go to heroic efforts to try to be able to fill it out on behalf of the seller, you're going to go in a bad place for that. Okay, so I wouldn't do that. But again, this was a comment that I had made in a meeting, the Zip Forms meeting, probably 20s. Yeah, it might be a little over 20 years ago, because our agents were filling them out on behalf of the seller, and then we get hauled into court, and the attorney on the calls the seller up on the stand and said, "Is this your disclosure?" And the seller says no, and they said, "Well, this is your signature," and they go, "Yeah," and they go, "Well, then is this your disclosure?" "Well, no, the agent filled it out for me." And so guess what? You're the professional, and so we had a lot of lawsuits on that. So now you don't have the ability to fill that out. So is or is not occupying the property, that's fairly simple. Again, this part here, that's going to be something that's going to be the client will have to do, again, with the advice and counsel of the agent. Down here, this is the part I see most frequently done incorrectly. Again, answer the question yes or no. If they answer the question yes, please give us a description of what that is. If they answer the question no, we move on to the next question, right? But if you don't answer, if the seller didn't answer one or the other of these, then it's going to be considered a defective TDS. And remember, the buyer has 2 years to sue on a defective TDS, just on the defect. Okay. All right. So then I get down to the top of page 2, and I've got same thing. Any significant, are you the seller aware of any significant defects or malfunctions in any of the following? Yes or no. Again, if yes, please give me an example or a description of what that is. And again, they don't have to go into great big, but if it is something that's complicated, then yes. But I think, explain it like there's nowhere in the TDS that talks about death on the property, even though the Civil Code 1710 requires the disclosure of death within the last 3 years. So that's when we're going to go into the SPQ in a minute. So, but for here, yes or no. If the seller is not aware of anything here, then they check no, and we move on to the next thing. Okay, so for those of you that again are doing transactional work, I don't need carbon monoxide device. I don't need the carbon monoxide detector notice, the CMD form we call it. I don't need, down here on the bottom, I don't need smoke detector. I don't need water heater bracing, because those are all covered as long as you're using the current TDS. And again, I don't know why you wouldn't be using a current TDS. So if you're using a current TDS, you don't need those forms, right? Please stop sending me those forms. So anyway, so again, we're in section 2 still. Let's talk about section 2C. I have never seen this completed properly, right? Normally I get one from the seller's agent, and so it'll be no all the way down. It's just not possible. Again, I'm not going to go through it in detail. This morning's presentation, I think, covered it pretty well, because we really only covered the TDS, SPQ, SPQA, and the AVID. And so we managed to do it pretty well within 2 hours. I'm going to kick that one up to the department. I'm going to want to get that one DRE approved. Most all my classes would be approved by the Department of Real Estate, I believe. But God knows I put enough research into them, but I just haven't done it. It's not inexpensive. It's expensive to do that. So, and again, if we get things DRE approved, then we're going to have to charge for it to try to recover our expenses. But anyway, just take my word for it. C, there's just no way that you could answer no to everything, okay? Especially because we added the word mold many years ago, so that you couldn't say no. You're going to have to say yes. There's no such thing as a property that doesn't have mold. And so when my seller says, well, okay, all right, I get it, mold, yes. And so down here they type in, number 1, mold is everywhere, right? And so I remember speaking with to a room full of attorneys, and when I told them that, they just all cracked up, because the truth is mold is everywhere. It's part of the life process, right? It's part of photosynthesis, right? So mold is everywhere. But really, what the legislative intent was is that really bad mold, and again, you're not qualified to tell anybody whether it's mold. I have a graduate degree in hazardous materials. I kind of know the difference between mold and mildew, but I always ask people, well, is it mold or is is it mildew? They go, oh, I don't know. Okay, well then mum's the word, stain noted, right? Not mold stain or anything like that. And I personally was involved in a lawsuit of property that I had purchased that ended up having stachybotrys, and so I can assure you I've got hands-on experience with how bad that can go. Okay, so again, $18,000 worth of work to fix it, but the HOA refused, and that's usually the genesis of the problem, is the delay caused by the offending party, and it ended up costing them 88 grand to do an $18,000, which is really a $12,000 fix, but because it took them so long to for us to go to court, it just got worse. So okay, so anyway, enough of that. Seller certifies that the information herein is true and correct. Again, the legislative body decided that was the word they wanted to use, and so the seller signs it. Thankfully, on page 2, you remember for the longest time our TDS bled over into page 3, and the seller would sign the top of page 3. I hated that, right? Because page 1 and 2 belongs to the seller. Page 3 belongs to us. Okay, so first thing, if the seller is represented, we're gonna, again, here's that language, based on a reasonably competent and diligent visual inspection of the accessible areas of the property. And again, as I said earlier, visual was not in the Easton case, although later on they did say that it would be visual. Again, I think you should be doing your inspection with the five senses, but again, you're limited to what you have to do. Again, I love the AVID form. We'll talk about that in a minute. That's going to be a Civil Code 2079 question, but you would have an obligation in most every transaction I've ever done. Although I did just do one a couple months ago where the standalone broker sent one over and said recommend physical inspection by licensed contractor, and of course I haven't seen that language in 20 years. But I guess they just haven't taken any classes. But anyway, I remember a trial I was in where the judge said to me, why is the agent shirking their 2079 duty of inspection? And I went, I don't know, Your Honor. That's just kind of on them. Okay, section number 4, if there's a buyer's agent. And again, please don't have the seller and the seller's agent sign section number 5 until section number 4 is completed by the buyer's agent. If it's an agent other than the seller's agent, then really they shouldn't be signing down here saying they have a copy of something when in fact they may not have a copy. They don't have a copy with the buyers. So I make them sign it again. We'll complete it and then we'll require them to sign again down here at the bottom. Everybody good with that? Let's get out of the TDS and get to some more fun stuff. So again, Civil Code 1102.3, common exemptions, and I can send you the exemption, the Q&A from CAR includes probate. Why? Because probate, it's a court, and they're not going to make any disclosures, right? The REO, if it's a true REO, by the way, a true REO is the foreclosing bank. If it's, and I represent banks that buy from banks, they're not covered by, they're not exempt because only the foreclosing bank is exempt. Bankruptcy, clearly federal court, and some trusts, not all trusts. Again, in a real estate transaction, I want something from the seller stating why they believe they're TDS exempt, and I almost never get it. It's usually the agent who said that they were exempt, and so I've got a couple of cases they're going to make their way to the Department of Real Estate on that issue because, listen, you want to be careful that you're not too adamant about your position, and so in these cases, the sellers were, in my brain, clearly not exempt. But how do we protect ourselves? We protect ourselves by asking repeatedly for the disclosures. Give me the TDS. Give me all these other things. And repeatedly they respond, go away. And so I'm going to print those emails and I'm going to save them in the file so that I have something to defend myself from the buyer later on, right? Because it's the buyer who sues, who finds out that something was wrong with the property that the seller didn't tell them about. And then they find out the seller wasn't exempt. And so I don't want to go for that, as we say. So again, CCAR form ESD, and so I'll show you that really quick here, moving right along as fast as we can possibly move. Exempt seller disclosure, good, you can see that. Where did it go? Oh, there it is right there, always at the bottom of the page, right? Okay, so here we go. Here's my exempt seller disclosure. And so again, the decision of whether or not a seller is TDS exempt is a legal one. So the broker who knows everything is going to create a problem, and they're not going to create the problem for me. Okay, so you need to have something from an attorney that says that they are TDS exempt. All TDS exempt means is that they don't have to use the form. They still have to disclose what they knew or should have known about the property if they know something, but they're just not required by law to use the form. Okay. And so I get down here, and this is the same language you see in the SPQ, roughly the same language. You know, are you, seller, aware of any of the following? They can't escape this. If they are in fact exempt, they still must disclose yes or no on these issues. Okay. Very first thing. Death of an occupant of the property upon the property. Okay, not bedroom number 2, anywhere on the property. They can be in the corner of the property, you know, crawling out off the property. I know it's a little too graphic, but crawling out of the property. They died on the property, so then they need to make that disclosure within 3 years. And again, as you probably know, Civil Code 1710 says that you must disclose the cause of death or manner of death if asked, but at the same time, no duty to disclose the death if it was AIDS or HIV related. Okay, so of course, then when you say, and they say, I don't have to tell you, well, then you know kind of what that is, because it's the only exception. Okay, all right. So anyway, enough about that. I do not want to run out of time today. So let's go on to the next form. My Avid. I love my Avid. Okay. Again, I want to point out what the Department of Real Estate is going after right now on my not my Avid, but on others' Avids. Again, shortcuts are never a good thing, folks. So here's the Avid again, Civil Code 2079. Remember, we saw that when we looked at the agency disclosure, okay? So 2079 is ours. It's the one that regulates what we do, okay? So make sure this is filled out properly. Make sure that the broker's name, it doesn't auto-populate. The drop-down will work, but it doesn't auto-populate because this can be used both for the buyer side and for the seller side, but it can also be used for units. And so here we see it right here, duplex, triplex, fourplex for units. Page 1 is all about, don't sue us. I think real estate agents should be required by law to read it one time. Okay, at least read it one time. Why? Because it says a lot of really good stuff. And we don't want to say things inconsistent with what it says. So interior, agent will not move or look under or behind furniture, pictures, wall hangings, or floor coverings. Agent will not look up into chimneys or into cabinets or open locked doors. It says right here, okay? I'm not picking locks inside the house. So I love this. I had an attorney call me the other day and they said, well, should the agent have opened up the cabinets? I said, no obligation to open the cabinets, okay? It says right here in the Avid, there is no obligation. So don't go to heroic efforts, folks. We're not going to measure square footage. Still the number one litigated issue against real estate agents. And then down here at the bottom of page 1, what this means to you, this is frequently in the cases that I've been in up on the board, for the jury to see. Defense counsel, usually defending the brokerage, says, hey, the agent's inspection and the seller's disclosure are not a substitute for the buyer's obligation to investigate the property. Okay. All right. Good stuff. Make sure this is all filled out properly. On the left side, we've got the date. On the right side, we've got the time, weather conditions. So if you put in there, sunny, and then plaintiff's counsel goes back and looks up the weather on that day, and it was Hurricane Hillary coming through, you're going to have a problem. So who was present at the inspection? I rarely ever see this completed. Make sure you put somebody in there. By the way, if the physical inspector was there at the same time you did your Avid, I think you waited too long. But again, their investigation of the property is not a substitute for your, speaking of, I got a lawyer calling me, is not a substitute for your obligation to, I lost my train of thought. That's so comical that an attorney called me right in the middle. So again, it is not a substitute for your obligation to inspect. Remember, the buyer's obligation is to investigate. Yours is merely to inspect. So don't overdo it. Okay, so here's my language again. How many times are you going to see this? Right out of Easton. Okay, right out of the Easton case. So follow the rule, do what you're supposed to do. If something doesn't apply, check, put in nothing noted. fill in the blanks. The district manager made a comment in a meeting, said that you need to defend the fact that you actually did the inspection of the property. Okay, so what better way? The Avid form has not been around that long. What, 15 years now? It has not been around that long. It is a great tool for our agents to at least be able to defend the fact. It's not about collecting your check. It's about making sure that you've gone out and looked at the property. You have an obligation at law. And the district manager said in the meeting, said, it's the only thing we ask you to do. And I don't necessarily agree. I think she was being humorous, but you have a lot of stuff you've got to do in a real estate transaction, but clearly an inspection, and clearly be able to defend the fact that you did it. And that's why this is such an important document. Okay. Again, nothing noted. One of my favorites, and I talked about it this morning when we talked about the Avid, but under garage parking, where the agent, ignores the fact that the driveway has cracks in the slab. Listen, our template says cracks noted in slab because they just all have cracks. I've never seen a pour that didn't have cracks in it. So, but I sure don't want to, not say anything. And by the way, one of the really cool features of this form up here, you see where it says photos, and this is true on the TDS as well. You can attach photos to the transaction. Whoops, wrong one. You can attach photos to your Avid. Pictures worth 1,000 words. You should have them in there, and then you have the buyer sign off, and the pictures will actually show up on the left-hand column. All right, so definitely have those pictures taken. I just think that's just a blessing. Have that done. Now, folks, here, I promised you, this is what the department is looking for. Once again, on a reasonably competent, diligent visual inspection of reasonably normally accessible areas of the property. Okay, so it says firm who performed the inspection. I think it should say that, but okay. Signature of the associate licensee or broker who performed the inspection. Right. So what the department is going after right now is teams where the firm name is listed up here. The agent that actually did the inspection goes into the office, and the team lead signs off on it. And the Department of Real Estate has said, we think that's fraud. And when the Department, 4-letter word, when the Department of Real Estate says fraud, run, don't walk. Trust me on this. They're investigating teams right now, complaints from the public, stuff like that. But the agent that did the inspection is the one that needs to be signing this form. Okay. Then we get down into a little bit further, and now we've got the buyer signing it. Obviously, the seller initialing it. Not required, but uses evidence that they received a copy of the form. The seller's agent will then sign. The buyer's agent will then sign the end. Again, remember what I said earlier today, when signatures are stacked, they're signed in chronological order. When they're side by side, it doesn't matter who signs first, but when they're stacked, they need to be signed in that order. Okay, everybody good? All right, so let's move on to the next one here. TDS is not considered complete until the seller's agent provides their completed Avid to the buyer. Okay, so somebody asked me this morning, great question. Well, what about the buyer's Avid? Well, it's not required to complete the TDS. You are required by statute to provide one, but the TDS is considered complete when the seller's agent provides their Avid to the buyer. Okay, all right. Appraisal discrimination addendum. Let me see, that's Civil Code 1102. So do we want to spend, some of these things that we're going to talk about? Let me see, where do we have that one? That's in your purchase agreement. It's down towards the bottom. Fair Appraisal Act addendum, it's called. There it is. And again, all that language will be filled in for you. But we wanted to. The statute requires that we give the buyer notice of where they can file a complaint if they believe that they've been discriminated against in an appraisal. Okay, so that's the point behind all of that. And then we have the final inspection report. So some of this stuff, final inspection report is going to be my FHDS, right? My fire hardening and defensible space. Only applies to property located in a very high fire hazard severity zone. Defensible space, again, that's going to be the form. 1102.19 is the civil code. I quoted all the civil codes for you. I assure you they're accurate. Applies to property located in a high or very high fire, same as before. Fire home hardening, again, 1102.6 applies to property located in a very high fire hazard severity zone. Carbon monoxide detector disclosure, again, Civil Code 1102.6. It's included on page 2 of the TDS. You don't need the separate form for that. Smoke detector, same deal. A bunch of regulations affecting that included on page 2 of the current TDS. Again, emphasis on current. Make sure you're using the current one. Water heater bracing statement of compliance, same deal. Again, I'm not going to pull up each of these individual forms. Again, page 2 of the current TDS. Water conserving fixtures compliance. Again, that's going to be 1101.4 and 1101.5. Not a point of sale requirement, applies only to real property built on or before January 1 of 94. Even the city of San Diego has removed the water conservation certificate requirement. They just feel like they've gotten pretty much all of them by now, but that was removed a year or two ago. Windows security bars, again, statutorily required. TDS has it. Again, I showed that to you a minute ago. The MHTDS, which is the mobile home transfer disclosure statement, has it in there. Homeowner's Guide to Earthquake Safety. Here's all the civil codes that apply to that. Here's the civil code that applies to you, 2079.8. You are required by law to give that. And again, depending on the natural hazard disclosure company that you're working with, whoops, I went too far. Depending on the company you're working with, it may not be in there. The one that we use is clearly got it in there. The Homeowner's Guide to Earthquake Safety, as well as the Environmental Hazards booklet, are required by law. Remember, that also includes rentals, also includes leases and rental properties. So if you obviously you're not going to probably do a natural hazard disclosure, but you still have to make the disclosure. And so I wanted to bring that up. So again, in my little template over here, I've got, notice I have my statutory disclosures, but then I have my NHD. And so I wanted to bring up a copy of an NHD. Let's just pull that up here real fast and go through the salient parts. So in a transaction, a sales transaction, you'll probably order a natural hazard disclosure, but you're not doing that in a rental. And so you're probably not, you may not even be doing rentals, but now that I've locked my screen, I've got the familiar spinny thing going on in the middle of the page. Yep, you can see the spinny thing. Okay, here it is. I just reached out and asked companies for a copy of a generic one, and this is the one that sent me back a response. So this is natural hazard disclosure. And by the way, it's not in the library. It's not in CAR's library. And the reason was because nobody was using it. I remember talking to Gov Hutchinson about it, and he said nobody was using it. So we just took it out. We were pretty much everybody was ordering it from a third-party vendor. So you'll look in this one here, it says very high fire hazard severity zone. So we just talked about a bunch of stuff that applies. So AB 38 disclosure form is going to be voluntary in this case, but you would click on the link, it would take you to the form, all that, et cetera, et cetera. The key point I wanted to make here was, when the original iteration of this came out in 1998, it said the agent certify that the information that the seller is giving is correct. Well, boy, we had a heart attack over that. So we spent 6 months trying to get again, this is legislative form, get the legislator to change the form so that it did not say certified, because we did not want to have, that we are certifying the seller's information to be correct. We did not want that to be. So notice that the seller signs the form. Please, first, don't have the buyer sign a bottom. Never have a buyer sign under a blank. Again, they're going to call that potential fraud. So the seller signs it first. The seller's agent signs it second. The third party is check the box here saying that we're going to be held, to the E&O insurance, et cetera, and then the buyer signs it. There's no obligation by law for the buyer's agent to sign it. And the reason that the statute doesn't require it is because the only requirement on the buyer is that a buyer's agent is that they provide it to the buyer. Okay, so no place for the buyer's agent to sign it. Okay, everybody good with that? Good, you can see it. Excellent. Holly, thank you for being here. I know you're going to check me in case I forget to pull something up. Okay, so NHD, there is no CAR form. It is Civil Code 1103.7, frankly. Why isn't it in the library? Because the CR, it just wasn't being used. Double check, folks, that your NHD company that you fought so hard for. Listen, I think if the buyer asks for a certain company, you need to let them have their company, right? I feel strongly about that. The buyer's agent should have gone over the various possibilities with the buyer. and prior to asking for it. But that's just how it is. Any questions on any of that so far? My hot tea is now iced tea. Okay, mining operations, there is no form, seismic hazard. Here's all the civil codes. Again, I looked all of these up. Special flood hazard area, these are all included in your natural hazard, hopefully in the natural hazard disclosure company that you're using. I mean, I watch real estate agents fight about this, and it's like, between that and escrow and title, I mean, what are we just looking for something to fight over? The fact of the matter is, forms are not all, these are not all alike. I just closed a transaction up in Malibu where, Mr. Number one Malibu agent said they all go to the same data source. I go, they do not actually, and they all have different coverages and they all have different E&O policies. And so I sent him a graphic of the differences between the companies, and he goes, wow, I didn't know that. And so you've been in the business a long time, doing things the same way he's always done it. I always love it when people say that, because I'm like, okay, well, listen, I've been doing this for over 45 years now, and I don't do things the way I was doing them back in 1979, okay, 44 years ago. All right, state responsibility area, I'm just going to go through these pretty quick. Very high fire hazard severity zone. These are the civil codes. Again, I'll send you all this. You just send me an email. 1103.4 on airport in the vicinity. It's required. It's a statutory requirement. Area of potential flooding. So your natural hazard disclosures: 2 fire, 2 earthquake, 2 flood. And so the area of potential flooding is covered in, hopefully, in your natural hazard disclosure. The form itself is statutory, but what they do is not. And I've been in a meeting where one of the natural hazard disclosures companies came in and complained to us about the fact that that a particular company was raising the bar. And so I kind of like that. I like the company that raises the bar. I don't like the one that just skates by doing the minimum required stuff. And I get it that there's insurance issues and all of that, but listen, step up. There are more laws coming, by the way. I talked to Gov about this the other day. We're going to make them create legislation that requires the natural hazard disclosure company to do that fire hardening for us. Right, the defensible space and fire hardening for us. There is a CAR form for tenants, by the way. It's called the Tenant Flood Hazard Disclosure, and this CAR form TFHD. Let me show you that just really fast. I want to go through that. We're actually doing pretty good. We're going to probably be done a little bit early. Let me get out of this. I'm going to pull up my where did it go? Back to my statutory disclosure. Again, the tenant flood hazard. This is an interesting form. So here we go. So we are required by law to disclose to the tenant whether or not the property is in a flood zone. So probably the best part of this form is the link to the website, which is right here. The San Diego County has a website. You can get to it by going here, but literally you type in the address and it pops up a thing that says that it's in the zone. It's not in the zone. We always print it. Especially on rentals, we're going to print it. But we're also always going to check the box that says the property is located in the zone. And why do we do that? Well, because because by default, we don't want to get, the default says it's not in the zone. And so as most of you have heard me say in the past, I'm not going for that, right? So if it turns out that I accepted the default, and a lot of agents just accept the default, but if it's in the zone and we said it wasn't in the zone, I think these should be reversed, right? I think we should say it's in the zone, or check the box, it is not in the zone. Why? Because if we say it's not in the zone, which is what the current form says, right? We say it's not in the zone and it is in the zone, we can't move the property out of the zone and into the not in the zone, right? And so as a result, the court's awarding essentially the cost of the property, the price of the property. Why? Because you can't move the property out of the zone. So we're going to tell people it's in the zone. We're just going to say that until we confirm one way or another. So our template says it's in the zone. Okay, and I think we should change this form, and I'll probably talk to Standard Forms about that in Anaheim next month. But we need to tell them it's in the zone, and then if it's not, so they can sue us if we tell them it's not in the zone, but in fact it is. But if we tell them it's in the zone and it's not in the zone, there's really no lawsuit there because there's no harm done, right? So just be aware of that. Okay, that's my TFHD. Then my earthquake fault zone, again, my natural hazard disclosure. We don't have a form for that because again, we're relying on you to use the third party form provider. Farm or ranch proximity. People think like, wow, really, seriously? And I talked this morning about the we had a couple of attorneys on that call, and I discussed the Del Webb versus Spur Industries case. And I know, Holly, you heard that. Jessica, you heard that this morning, Stephanie. But the Del Webb versus Spur Industries, Del Webb created a subdivision called Sun City on the northwest side of Phoenix, Arizona, way out in the middle of nowhere. In fact, on the route up Grand Avenue to get to Vegas, but way out there. And so, they sold all these properties, 55 plus community, something I'm way past qualified for. But it was next door to a stockyard. So in California, we require the disclosure. In Arizona, they didn't. And so Del Webb, the homeowners in the area all got up in arms, and Del Webb said, yeah, we're going to make them move, right? Because, it stinks, right? That kind of thing. And so Del Webb filed a lawsuit, went all the way to Supreme Court. It was called Del Webb versus Spur Industries. And I'll send you the case if you want. Send me an email. But great case. And so the court held in favor of Del Webb. They said, yeah, you're right. Spur Industries, the time has come that they need to move. They're now in the path of progress. Oh, but by the way, Del Webb, you brought them here. And so it coined the term. The holding was, coming to the nuisance. So you created the problem because you brought everybody here. And now that they're here, now all of a sudden they're noticing the noxious odors. So again, in California, we have that farm or ranch proximity required by Civil Code 1103.4. But in Arizona, they didn't have such a thing. So I'm pretty sure they still don't have such a thing. But again, I let my Arizona license go. I just did not want to ever go back. Oh God. Anyway, needless to say, so be aware of that. Okay, FHA HUD inspection notice. Again, there's a HUD mortgagee letter that's usually handled between the lender and the buyer, the purchaser. Common interest development. Again, there's my favorite right there. Civil Code 4525. It's in your purchase contract, folks. It's right inside of your purchase contract. So let's take a look at that. So when I go down into here, we're going to get into my common interest disclosures right here. Here's my Civil Code 4525. Listen, it's a statute. Okay, so why are we talking about it? We're talking because it is a statutorily required thing. So guess what? Buyers got time to rescind the contract based on when they get it. So we always narrow it down in here. Who the time period to pay for the HOA docs. We changed the 3 to a 1, and then later on it'll talk about who's gonna pay for it. This is just how long. We want to get that done right away because remember, again, the buyer's got 17 days or 5 days from receipt, whichever is later. So if you don't give them the HOA docs until day 20, they've got until day 25 to rescind the contract. Do you want them to have that much time? And again, if you're doing transactional work, you need to be monitoring, the activities that are going on and making sure that these are ordered right away. Okay, so advisability of title insurance. Remember that our contract, we don't have a form for that, but our contract says that when you remove the investigation contingency, you remove the title contingency as well. Or I'm sorry, back up. Insurance contingency, the hazard insurance that we call it. Advisability of title insurance. There is no law that requires title insurance in California. But the courts have held it's easy to obtain, readily available, fairly inexpensive. And of course, the lender requires it. So you as an agent don't ever want to tell the buyer they don't need title insurance when they're paying cash. I wouldn't do that, right? Okay. Pest control inspection report and certification. So again, this is covered in the contract. There is no law that requires pest inspections. Okay. However, it's called a wood destroying pest or organism inspection. It's not called a termite report. Please stop calling it a termite report. It's not a termite report. It covers many things besides the fungus among us, the dry rot, the critters, all that stuff. It's a pest inspection. Okay. And so it's Civil Code 1099. Seller's agent, this is a statutorily required part of it, must deliver the inspection report and the subsequent certification of work completed to the buyer only if required by contract or the buyer's lender. So we removed it from the contract, right? And so it's not in the contract anymore. But the buyer's lender might require it. That's normally what we call an overlay. So it's not required by law, but sometimes the buyer's lender wants to pad their file because remember, they're going to go sell this loan to, Fannie Mae or Ginnie Mae or Freddie Mac. They're going to sell this loan on the secondary market, and some of them just feel like it makes the file look good. Okay, so just remember, there's no law. There is a law that says if you've got a copy of the report, then you need to provide it to the buyer. Now, what does plaintiff's counsel do? I love this. So buyer gets a report. The agent put it in the contract because they just can't get over the fact we don't have a WPA anymore. And so the agent puts it in the contract. Now the lender requires it because they see it in the contract. And the buyer gets a report that says there's no critters. You got a free and clear. Then the buyer moves into the property, and then they see this sticker on the water heater that says that the property was inspected by a different company, and they left their sticker on the water heater with the date that they inspected it. And the buyer goes, wow, that was right before the report that we got. And so what does plaintiff's counsel do? Plaintiff's counsel goes and looks up on the state contractor's website. You just go up there, you type in the address of the property, and it'll let you know all the reports that were done on the property. So plaintiff's counsel goes there, and they see 5 inspection reports until the seller got one that said, the pest company doesn't know what a termite looks like or dry rot or any of those other kind of things. So this is bad news for us in real estate. Let's take a look again at my purchase agreement, and I'm going to take a look at paragraph number 12B1C. Let me fast forward here a little bit. 12B1C. So 12B1C, again, remember, the buyer's obligation is to investigate. It's not the seller's obligation. Seller's obligation to disclose what they knew or should have known. So here under 12B1C, we see an inspection specifically for wood destroying pests and organisms. This is the buyer has the right to do this. Any inspection for these things shall be prepared by a registered structural pest control company, shall cover the main building and attached structures, et cetera, et cetera, et cetera. But, this is all the language that used to be in the old WPA, okay? And we got rid of the WPA because it was getting us sued. And so, listen, I don't want you to have to worry about this stuff. But again, we always had the seller paying Section 1, buyer paying Section 2. We got rid of that. So what happens now? The buyer can go in and have an inspection done of the property, a pest inspection done of the property. And what do? They submit it. If there is a finding, they can submit it as a request for repair. It becomes a negotiable item rather than those agents that, were looking to blindside. I had an agent say that. And in our office, we let him go. He said, yeah, I want to blindside the seller. And it's like, no, we're not here to take advantage of people. The seller is agreeing to do stuff they didn't even know what it was until they get the report. So, so let's keep it on even keel. Just make it a regular investigation and a standard request for repair by the buyer. Okay. All right. So again, 12B1C, I just showed you. Private transfer fee, there is no form, but it's required by civil code. The methamphetamine contamination notice, otherwise known as the MCN, is again health and safety code. Why? Because meth kind of hangs on to a property. It has to be professionally removed from the property because even after the meth has been removed, it still has the potential to go boom. And I mean loud boom. So if there is, it'll be a recorded document. And so you need to make sure that is disclosed. It is a statutory disclosure. Flood disaster insurance requirements, again, 42 U.S. Code 5154A, groundwater basin. These are all disclosure. All these things, most of these are covered in your natural hazard zone disclosure report, folks. Okay, your supplemental property tax notice, I don't need to get a separate form, right? It is included in the SBSA. Okay, and so we use the SBSA in all of our transactions, and even in some cases in our rentals. But supplemental property tax notice is included there. We don't need the SPT form. There is an SPT, but we don't need it if we use the current SBSA. Gas and hazardous liquid transmission pipeline notice. Again, it is a statute. You're probably never going to see it It's Civil Code. Again, our obligation is under Civil Code 2079. It is also in the SBSA. So I think you need to be doing that SBSA form, okay? And then more specifically, the LAD, the Local Area Disclosures Form, because the Local Area Disclosure Form is going to have, like for example, were you aware that there's an 8-foot pipe running down underneath Rosecrans in Point Loma? Now, it doesn't mean don't drive there, but we fought bitterly to prevent the disclosure of where those pipelines were, because we wanted it for protection from terrorist activity. But unfortunately, the legislative body overrode us and said, no, we want you to disclose it. We'll just take the chances, I guess. So meth lab cleanup order, we talked about that a minute ago. A release of an illegal controlled substance or remediation order, death on the property in the last 3 years. So again, on the property, we've talked about this already. It's California Civil Code 1710.2. You must disclose the death within 3 years of the on the property, anywhere on the property. Megan's Law disclosure, again, you're required by Civil Code 2079 to make the disclosure. It is the registered sex offender database. When I go to the purchase agreement, I'm going to go to the statutory disclosures, which are in paragraph number 11. Here it is right here, 11I, Megan's Law database disclosure. So folks, I don't need the form again. It just, I have an obligation by law to disclose the existence of the database, and I'm doing that in the contract. So I don't need to do it again, okay? And so I added some other notes. Duty only to disclose the existence of the database. It's included in paragraph 11I. By the way, criminal penalties if you go to the database, if you're on the database, it's actually $1,000 penalty. I remember I shocked an attorney one day when I said, it's against the law. If you're on the database, it's against the law for you to go to the database. So I always say that, and I always say I've never been to the database, right? Not because I'm on the database. I mean, you would know if you're on the database, right? Because you were convicted of a crime and you were put on the registered sex offender database. That's what Megan's Law is, right? So I've just never gone. The reason I don't go is because I've been in enough court cases, enough depositions, where they say, well, why didn't you disclose the registered sex offender next door? And it's like, well, I didn't know there was a registered sex offender next door. Okay, I read enough depositions. I've never been deposed on the subject, but I've read the depositions. And so, well, when's the last time you went to the database? Well, I was in there 6 months ago. Okay, well, they were in the database 6 months ago. Why didn't you disclose to the buyer that there was a registered sex offender next door? You see where this is going? This is just getting really ugly, okay? So my advice, don't go to the database. You will be held to have constructive knowledge of everything in the database from the date when you go to the database. So I would recommend against going to it. If you do, make a note of it, what the time it was. Remember when it first came out, you had to go down to the sheriff's department and they had a book. And oh, by the way, when you went down there, they had you sign a document that said you were there and you looked through the database. So, today, after a couple of years, now we require the Department of Justice to publish the database, and that's where you got Megan's Law, ca.gov, right? So again, when I pull that, whoops, wrong one. When I pull that up, I'm, where is it? Here it is right here, meganslaw.ca.gov. And by the way, it's a national law. I'm pretty sure this came out of California, but everybody's got it now, okay? So, just be aware of that, all right? So flying along here, notice the special tax and or assessment. So believe it or not, Mello-Roos is a statutory disclosure. Okay, so when does your seller disclose Mello-Roos? Well, it's not in the TDS. Okay, it's in the SPQ, right? It's also in the natural hazard disclosure company that we use. And so remember that the buyer's got a 3-day right to rescind the contract if they're not told about the Mello-Roos assessment, after the contract comes together. And so I had a property, I sold it in Carmel Village in Carmel Valley, where the seller said, we don't have Mello-Roos. And I said, you were built in 1996. You have Mello-Roos, right? Because Mello-Roos came about in October of 1988 in San Diego County. And so he says, we don't have it. And so I said, okay, let's take a look at your tax bill. And right there on the tax bill, was the Northwest City, Neighborhood Coalition District, which was Mello-Roos. Community Facilities District, I'm sorry, CFD, Community Facilities District, which is Melrose. And he said, I didn't know that. I said, well, I kind of knew you did. Not that you knew it, but he said, the agent didn't tell me that when we were buying the property. We're paying Melrose. I don't want to pay Melrose. So, great big thing going after the other agent. Sorry about that, but I'm selling your house and we're going to disclose the existence of the Melrose, and we're going to do it before the offer comes in, which we did. We made all the disclosures prior to contract. Can you imagine doing a file with me? I mean, what do you need 30 days for, right? Okay, so Civil Code 1102.6, it's also government code. It's also, it's just a lot of code. If seller has actual knowledge of industrial use and military ordinance, no I in it. So an ordinance is a rule or regulation, usually a local one. An ordinance is something that goes boom. So Coronado, Tierra Santa, Oceanside, they got stuff that goes boom. And this is 1102.17, also Code of Civil Procedure 731A. So those are my statutory disclosures. Okay, so let's talk a little bit about my contractual disclosures. So we'll get out of statutory here really quick. We're going to go over here to contractual. Notice I got a whole list of them. We're not going to pull all these up, folks. But I want to tell you, I just want to show you the distinction between the statutory disclosure and the contractual disclosures. So remember, statutory disclosures are very, very important. I think we found in our discussion that most of the statutory disclosures are going to be covered in the NHD. Hopefully, again, double check. Because they don't all provide all of these disclosures. I'm aware of one company doesn't even do the environmental hazards. And remember, the law requires the environmental hazards. So contractual disclosures, what is it? Again, contractual disclosure is going to contain cancellation right. So remember, my statutory disclosure, buyer has the right to rescind the contract, which means just make it go away. Probably going to get their deposit back. Again, it has to be a material fact affecting value or desirability of the property. Probably going to get their money back. Do you want that to happen to you 21 days into the transaction? Okay. Contractual disclosure, very different. So what is that? My physical inspection contingencies, my contractual disclosures are going to be things that the buyer may be an opportunity for the party to exit the contract without penalty. Maybe rescission, yeah, probably. But here, and I've had this happen. I've had some really good, if there can be any such thing as a good lawsuit, but there've been some really good lawsuits where the buyer tried to get out of the transaction and they were held not to be able to do so because the reasons were not material. So for example, I had a broker that I was when I was management with the Red people, broker said, we're canceling transaction. And I go, our listing. I go, why? Why are you canceling? They said, well, I don't have to tell you. I go, you don't have to tell me? Really? Seriously? Tell me about that. And they said, well, buyer can get out of the transaction for any reason for 17 days. Folks, please don't tell buyers that. Please don't tell sellers that. That is not the law. All right. So buyer cannot get out of the transaction for any reason. It has to be a material fact affecting the value or desirability of the property. Listen, it comes right out of the statute. Okay. So what's your reason? And this poor guy, I wasn't going to give him his reason. I kept saying, you need to give me a material reason or material fact affecting the value or desirability of the property. He wrangled on it for a week and finally figured it out. He must have talked to his broker who said, give him a reason why the buyer is trying to get out. Again, remember what I said earlier, if the kitchen lights aren't working, if it's just the bulbs, that's not going to be a material fact. Can you imagine sitting in front of the judge? There's a principle of law called the laugh test. And that's when you tell the judge, I tried to get out of the transaction because the light bulbs weren't working. And so you spent hundreds of thousands, maybe millions of dollars to get here in front of the guy or the gal in the robe, and they're like looking at you like you're nuts. This is called the laugh test. When they start laughing uncontrollably, your case is gone, right? So you don't want to have the laugh test. You don't want that to happen. But if those light bulbs aren't working because of a electrical problem in the house, maybe there's an opportunity to get out of the transaction, but you're going to definitely need a supporting role from somebody. You had the electrician out there and the electrician said, this is going to cost $10,000. I think that's material, right? So $10,000. Again, it's the judge's decision whether it's material or not. It's not my decision. So remember, statutory disclosures include rescission rights. Contractual disclosures include cancellation rights. I just wanted to summarize that. I love the RA form. And so I put this under, it's not a disclosure necessarily, but it is. It's a disclosure of the difference between a licensee and a Holly, question. Holly, you got your hand up. Are you giving me a high five? Thank you, Holly. I really think you need to be using this RA form. Okay. Here we go, Holly. Sorry. No, don't be sorry, please. I'm so glad you're here. I really am. Thank you. Please don't apologize for being here. It's important. So thank you, Holly. So again, I'm going to go to my RA form. Okay. So I love my RA form. Here it is, the realtor acknowledgement form. Okay. So as I mess this up, here we go. Okay. So here's my RA form. My RA form says that it is against the law for you to say that you're a realtor when in fact you may only be a licensee. So remember again, 435,000 realtors in the state of California, less than 200,000 of them. I'm sorry, back up, making sure I said that right. 435,000 licensees in the state of California, less than 200,000 of whom are realtors. And what's a realtor? It's somebody who's a member of the National Association of Realtors. They subscribe to a written code of ethics. They agree to be held accountable to that. So BMP code 10177 says that if you call yourself a member, really what it says, a member of a trade organization when you're not, which is Realtors NAR, and you're not a member, they can take your license. They can prevent you from renewing. They can keep you from getting a license in the first place. You can't get a job as a janitor in a building that has a real estate office in it. Okay, so you want to be careful. I have a transaction right now where the license expired over 6 months ago, and yet they're still claiming to be realtors. And so I'll be having a conversation with the former broker. But anyway, realtor acknowledgement form, again, we created this in 7 of 06. Great form. This is the first form I ever sign in front of the client. So remember, my agency disclosure is the first form that the party, the buyer or the seller, are going to sign in the transaction. But I am going to sign this one. And so, read it once. Will you please? Just do me a favor, a homework assignment. Just read through it. It's really powerful. And so I feel this is in every transaction that we do, whether we're representing the buyer or the seller, the landlord, the tenant, I don't care. We're having this form in every single transaction we do. You need to let everybody know that there is a difference. And my client, I say to the client, I said, here, I want you to see this. And they say, well, we thought you were all alike. And the answer is no, we're not all alike, right? There's a difference between, whether or not I subscribe to a written code. Now, I didn't say that the others are not ethical, right? I just said that I subscribe to a written code of ethics. That's all. I didn't say that they weren't ethical. By the way, here's the problem for the client. They're sitting there scratching their head. Well, I thought everybody was a realtor. Now they're starting to question your competition. They're starting to question everybody else that they've been talking to who said that they were, did not say that they were a realtor. Now they're wondering. They know you subscribe to a written code of ethics, but don't know about anybody else. And by the way, nobody uses this form. Our brokerage requires it. We do it for sure. I think you should require it in your real estate transaction. Everybody good with that? First form you should sign in front of them and give them a copy of it. It's a very powerful, it's one of my best closing documents, okay? One of my best closers. They're gonna work with me because I explained the difference to them, and they didn't realize it, and now they wanna know, okay? Then I have my seller property questionnaire, and so, I discussed this at length this morning. We're not gonna have enough time really to go through it, but be aware of the form. The seller property questionnaire is going to be my, essentially my addendum to the transfer disclosure statement, right? I'm looking for it. Where did it go? Sorry. There it is. Okay, good. So my seller property questionnaire, here it is. Again, please use the current version, revised in June at 1:30 in the afternoon. I think you've heard me say I'm sitting there clicking the refresh button. I was so excited about the new forms coming out. I knew what they said. I knew what was in them, but I was just so excited to be able to use them. You would never want to use the form before it comes out. Oh, by the way, we're already working on December. Okay, so there are going to be some changes. So if you want to know what those are, go up here where it says Forms Library, and then click on the drop down right here where it says form update for 623. When we've got the new forms ready to go, it'll say 1223, okay? But you know me, folks, I'm going to be doing a class for you on the new forms. We're going to be talking about those way before December, way before the publication, way before the release, okay? So this is my seller property questionnaire. And again, I really killed this morning. So just remember that it also contains the exempt seller disclosure. Paragraph number 6 is essentially the exempt seller disclosure, in the event that the seller is TDS exempt. But again, this is my second of 3 parts: TDS, SPQ, SPQA. So the SPQ dissects the TDS and says, there's a lot of stuff missing. Like, for example, right here, death on the property within 3 years, the death of an occupant of the property upon the property. Again, not bedroom number 2, but somewhere on the property. Note the seller manner of death may be a material fact to the buyer and should be disclosed except for a death by HIV/AIDS. So, like, for example, Heaven's Gate, right? Property in Rancho Santa Fe. We showed it about 2 weeks before. 40 people off themselves. I know we weren't responsible for that. At least I'm pretty sure we were able to defend that case. No, 40 people killed themselves in the property. So, so do you need to disclose the death on the property? Yeah. Within 3 years. Yeah. I personally think it's probably going to go on through eternity, right? The city of San Diego, which is Rancho Santa Fe, changed the name of the street. Because now the street was stigmatized, right? The purchaser, the property was for sale for $2.2 million. It sold for $750,000 because all these people were afraid of, the death on the property, right? 40 people, okay? And so the buyer of the property leveled the property, built a whole new house on the, folks, it needed redoing, right? Because it was a dated home. I remember the agent that had the listing. I keep meaning to call him just to see how he's doing, but boy, how'd you like to have that listing? But it's kind of like the Sharon Tate murder. I think it's one of those things that carries with the land. I think personally. So 10 years later, the Union Tribune posted a picture from the helicopter looking down on the compound. It was a big house, looking down on the property. How would you like to be the buyer of that property and look at a picture and you go, hey, that's my house? How would you like to find out about that, right? So again, if somebody's going to be have a problem with it, let's have the problem before closing and not after closing. Joe Jelly used to say your lawsuits all happen after close of escrow. So they really don't have any harm or any damages except maybe inspections and things like that prior to closing. So I actually have a lawsuit right now where they're suing each other and they're not even done with the transaction. It's like, how are you doing that? I was like, wow, that is really cool. Okay, so seller's affidavit of non-foreign status. Again, that's going to be my Foreign Investment and Real Property Tax Act. We also have the qualified substitute form, and this is several codes, tax codes. I am going to pull that one up. I wasn't going to, but I am going to pull up the FERPTA, we call it, and here's why. Because this form creates a lot of confusion for people. So let me pull that up for you really fast, and we'll go through it. We're going to be done a couple minutes early, but not an hour early, obviously. Where's my FERPTA? I should do this a different way, but not. Where is it? Oh, there it is. Okay, FERPTA. Okay, so let's take a look at my FERPTA. So again, each transferor, so if you've got husband and wife, each one signs their own. Okay. And again, notice that grayed out field again. The property address will populate, but the transferor needs to put their name in there. I think we should be able to do that, but okay. This happened as a result of that comment I made about agents filling out the TDS, and then of course CAR went crazy, and they just crazy in a good way, right? Listen, they're trying to protect us. And so transferor's name, and then down here, paragraph number 3, the seller is going to be able to check one of these boxes or not, right? So if they can't check one of these boxes, then they're going to be subject to withholding for U.S. income tax purposes. So they're either an individual transferor who is a non-resident alien, or they are a corporation, partnership, LLC, trust, and estate. And I would tell you a domestic corporation is a California corporation. For example, we're a domestic corporation in California, but in Virginia, we are a foreign corporation because our corporation is in California. So we are a brokerage in Virginia as well. So we have that ability to, now we are a foreign corporation in Virginia. But again, they're either going to check, if they can't check one of these boxes, and you need to be really careful about explaining to them whether or not it applies to them, folks. Listen, please, you do not give tax advice. Okay, so the mistake I see frequently is that the seller will check number 4, in which case they're going to provide the buyer with their SS number. I don't want that in my file. So for that reason, I'm probably going to recommend they not check 4. Therefore, they don't fill out 5. And then we'll have, because this gets really ugly. Make sure the information is filled out properly. Again, the name of the individual, but if they're a trustee, then trustee. Buyer's name should be filled in here. By the way, there are penalties for the buyer misusing the information. This was a problem with the form when it first came out, but now we've changed it so that we can just get a QS form. But notice, don't miss these initials. Buyer seller initials on the bottom of page 2. Okay, so make sure that we get that done as well. So what else in here? SDR forms. SPQA I think is an awesome form. Again, I think that the TDS is just wholly inadequate. The SPQ does a great job of trying to fix the TDS, but I'm going to use all 3. I'm going to use the seller property questionnaire addendum with the SPQ, again, appropriate for San Diego County. And again, they don't look to reinvent the wheel. They just want to cover the stuff. So like paragraph number 5, there's really nothing to say because the SPQ covered it, right? Paragraph number 6, the SPQ covered it. Okay, paragraph number 7. Okay, so we think this little bit of something should be added. 8, we think there's a lot of stuff that should be added. But again, this is going to be a 6-page form. And again, my hat is off to the attorneys on San Diego's Risk Management Committee. And, they went through all of this stuff. I mean, that was a lot of work. I was on the committee for 15 years. I don't know why I'm not on the committee right now, but it just works out that way. So, but the bottom line is that there's a lot of stuff that are not covered. Water related and mold issues are covered just fine in the SPQ. Pets and animals and pests, fine in the SPQ, but then paragraph number 12, we felt like we needed to expand on that. And so anyway, great form by the San Diego Association of Realtors Risk Management Committee. Addendum to purchase agreement, same thing. I like the addendum to purchase agreement, and here's why. I'll just bring it up here really quick for us. Let me go back here. I can find it pretty fast. Addendum to purchase agreement, here it is. Again, these are not statutorily required, but standard of care in San Diego County. And so here's the one that calls out the SPQA and the SPQ and the VLQA if necessary. And so, we use these in every transaction in San Diego County. Okay. Financial interest if I have one. License, we don't have an equivalent form on the state level where the agent would disclose their license status. So if you're the buyer and you have a real estate license and you're conducting activities that need that license, you're required by law to disclose the license status. So here it is. This is a form that you can use for that purpose. Again, and I had a case where I argued and the court agreed that the agent did not need to disclose their license status because they didn't do any license activities in the transaction. They were just a seller. Folks, it's a very narrow interpretation of Civil Code 2079. Just take it for granted. Everybody that has a license, you either disclose if you're the buyer or seller that you have a license or that you are related. In the second part, number B, you're related to somebody in the transaction. You are the agent and you are related to, like, for example, my brother. I'm selling my brother a house. I must disclose my affiliation with my brother, right? My familial status, we call that. Okay. Everybody good with that? Questions on any of that? Seeing none. Almost done here. Gosh darn it. Do your warnings. I'm going to skip through this, but again, I'll send you this PowerPoint. I think you should be disclosing all these things to the parties. So I do thank you for joining us. I am going to get you out of here a minute early. Disclosures. If you want to view any of the webinars, and again, after this one finishes processing, they got to take out all my bad language and everything. After this one's done processing, I'm going to load all of this week's up into the YouTube website. So get your QR code reader ready. There it is. Take a picture with your QR code. It'll take you right to the website. You can also type in your browser at Burke Real Estate Consultants, Inc. Again, I had to create this because the DRE is requiring me to put the document up there. To tell you about that RPA class, the 5 hours of continuing education, they've already proved it. So hopefully I'll be able to teach that class at SDAR here coming up in September. So I'll be talking about that with the EO on Monday. Or there's a bit.ly link, and that's bit.ly/real-estate-ed. Case is important. Here we made it all lowercase, but again, you'll be able to go to that website and you'll be able to find that form if you want to sign up for the class. Please remember to like and subscribe. Like makes me feel good. I appreciate you when you do that. Subscribe just notifies you next time you go to YouTube that I've loaded the other 4 videos. Okay. If you have anything you want us to talk about, education@sdar.com. You can send it to them, copy me. You can send it to me, copy them, whichever way you want to do it. We want to help. SDR is famous for their education. So folks, take advantage of it, learn from it. I'm preaching to the choir. You're all here today. We have weekly updates that I send out, if you're not on the newsletter. The newsletter contains, by the way, direct links to the classes that we're doing. You bypass the part that says that the class is sold out. I want you in the class, folks. We have a lot of people attending these. At this point, I haven't hit 500 yet, but that would be the limit. But heck, I'll do it again. Okay. But again, that RPA class is going to be live in person. But I know when I do my classes, we get amazing attendance. So anyway, any other questions, anybody, anything you can think of that I can help you with? Again, please let me know. I do thank you. I mean, I look at the list of people that are on here. Nobody else can see it but me, but I feel like we have some real celebrities here. And I do thank you so much for your loyalty coming back again and again. And so assuming I don't get fired on Monday afternoon, I don't know. It could happen, right? But hopefully I'll get to see you on Tuesday. So anyway, thank you all for being here. I wish you the very best of the weekend. I hope you have a great time. And if there's anything I can do to help you, please reach out to me either by phone or by email. I thank you again. As we say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Take care for now. Have a great weekend. Bye-bye.